All right. Oh, really?
That happened last week too. We used to put everybody on notice. Please don't call me.
I guess so. I totally need to do that. All right. So let's see.
Or they need to make the phone understand. Hey, he's recording right now. You shouldn't.
That would be better for the engineers to create a call block while
I think that would be something we need to work on for sure. Like, forget all this other stuff. Like, that's so top priority. We should totally do that. All right. Welcome to episode 22 of the Qierre and Wesley Show. I'm your host, realtor and author of the Blueprint to Successfully Selling Your Home, Qierre McGlory. Along with me, my business partner, my lender, Mr. Moneyman himself, and Axia Home Loan Sales Manager, Wesley Oliver. How are you doing today, sir?
Excellent. How are you?
I'm doing well. Very excited today because we have a very special guest, a state attorney, probate attorney, and all-around mompreneur, Adriana Reza of Adriana's Law. How are you doing today?
Good, thank you. Thank you for having me today.
Of course. Now, if you guys have been listening to... You probably saw my video that I did. And...
Technical difficulties.
Yeah, sorry about that. We've been doing the show. It's like 22 episodes in, and people still don't know that on Fridays we're doing our show. All right, perfect. Now we're back on. Anyway, so I'm sure you guys probably saw the video I did. It was pretty entertaining. You know, wills, trusts. What are they good for, right? Well, we're going to find out what wills and trusts are good for today because we have our expert with us. So, for most people, I mean, when they think of wills and trusts, either A, they don't know what a will and trust is, or B, they feel that a will or a trust is something for wealthy people that have a lot of money.
Yes.
But you're here to shatter that myth.
I am. And that can't be farther than from the truth in California. If you are a homeowner in California, I always tell everyone you absolutely need a living trust.
Okay.
Actually, in the state of California, if you have over $150,000 in your estate, they're going to make you go through the probate process or through a living trust process. Now, you are real estate professionals.
Yes.
I assume that you know what the median house price is in California.
Oh yeah, about $740, I'd say now.
Yeah. So just about everyone has something worth more than $150,000.
Absolutely.
Yeah, if they're a homeowner. So that's the piece of information that I try and communicate to my clients, that they are putting themselves and their family at risk if they do not have a living trust or at minimum a will to protect their family and protect their legacy, protect everything they've worked so hard for that they want to pass down to their family and to their heirs.
Absolutely. So you hear wills, you hear trusts. I mean, what's a will? Let's start over there. What's a will?
Okay, so a will is the simplest form. It's a legal document. Mm-hmm. It's usually got to be witnessed by at least two people. Okay. Sometimes you can get away with just one witness if it's something called a holographic will. Which
holographic.
That
sounds pretty cool. It's like a hologram or something, right?
Yeah, actually, it's not. It's very misleading. It's actually when you write it by hand. Right?
Oh yeah, that's very misleading. It's a lot more than I thought.
Rather than typing it out in this day and age, if you actually write it out by hand, it's something called a holographic will, and it actually is considered a piece of evidence that you would present to the court as far as their intent of how they wanted to devise things to their heirs.
I see.
And because it is written out in their hand and hopefully identifiable by someone that it was their handwriting, it kind of gives it more evidence, more credence that it was their intent. You can have a will that is both a joint will from husband and wife. Mm-hmm. You can have an individual will. Just because you're husband and wife does not mean you have to have a joint will. You can have two separate wills.
Okay.
The same goes with a living trust. And I'm getting ahead a little, I think. But so a living trust is a longer, more formal legal document. It also has to be witnessed. It's usually prepared by an attorney.
Okay.
Just about anyone can write their own will. Mm-hmm. But usually if you're going to be writing a living trust, it's a little more complicated and you want to have an attorney or a professional prepare it for you. It's going to be much longer. There's certain laws and provisions that you have to satisfy with the trust. And again, you can have a joint trust between husband and wife. You can have an individual trust. Non-married people can have their own trust. You can have something called an AB trust.
AB trust, okay.
Yes, which is usually what wealthier individuals or families with significant real estate holdings will do, because it's a living trust, meaning they both jointly control it during their lifetimes. But as soon as the first person passes away, it separates into an irrevocable trust and a living trust for person B. That's why person A's property becomes an irrevocable trust, and person B's property that's the still living spouse still has an existing living trust.
Perfect. Now, when it comes to the wills and trusts, I mean, why would a person choose to get a will as opposed to a trust?
Well, the number one thing that I say I see in practice of why people might choose the will over the trust is the price tag. Okay.
Okay. Oh, yeah.
So a will might just cost somewhere from $199 to prepare up to maybe $300-400 to prepare. Whereas a trust, I've heard everything from $2,000 to $5,000 or $10,000 for a trust, depending on how many properties, how many assets, what do you have that's going to be put into that trust. And also the state of California now has recording fees per page.
Per page? Oh, wow.
Yeah, it's per page as of 2018. So if you have extensive real estate holdings, that trust price is going to be bumped up because we have to pay the state for the recordings and the transfers.
Oh, wow. Like California doesn't have enough money, right? Jeez, not like a charge per page. Jeez. Because, I mean, looking at trusts, I've seen trusts easily 13 pages, 14 pages. Now you got to pay per page. Wow.
Well, it's actually the recording of the deed that transfers the property into the trust that they're going to charge you for. So hopefully if you have an experienced document prepare, they can get that grant deed into one page.
Yeah, I mean, that's possible.
With the tiny print.
Yeah, that's possible. I've seen that before. But it's been, minimum pages. But okay, so that's better.
That's better.
Okay, perfect. So so like I said, between wills and trusts, I guess what's the difference between them? Because obviously I know the price, but what's the real difference between wills and the trust? If a person asks, hey, if I want to pay only, no more than $500, I'll just get a will. And if I'm okay with paying more, then I get a trust. But what's the real difference?
Well, it's the difference between planning now and planning ahead or paying for it later. So with the will, yes, it is less expensive. But when it's just a will, according to California, you're going to have to file, your heirs are going to have to file a case in probate court.
Oh, okay.
And they're not going to just automatically be given permission to dispose of the properties, the cars, the bank accounts, the retirement accounts that you may have written about in your will. They're going to have to go to the court and file a probate case, and they're going to have someone appointed as representative of the probate estate, and they're going to have to ask court permission to take certain actions. And that's where it gets lengthy. It can be 1 year to 2 years in California to complete that probate process. It can be very expensive because you've got to pay not only filing fees to the court, you're going to have to now pay probably an attorney that's going to have to navigate through probate court with you. And instead of that one-time upfront fee, now you're going to be paying potentially an hourly fee or a percentage of the estate to your attorney.
Oh, wow.
Yeah, and that's actually written into California law, what percentage. As the estate grows, the percentage of the attorney's fees get higher.
Oh, wow.
Yes. So that's the difference. And then with the living trust, as soon as you file an affidavit of death with the death certificate of the person that passed away, usually the trustee then has permission to act according to the powers that were granted in the trust without having to go through that probate process. So that's the biggest difference. And as long as you have someone that you trust as your trustee, and hopefully you thought about that when you were meeting with your attorney and writing it up. It should be a smoother and just better process with the living trust.
Yeah, for sure. Wow.
Okay. So let me get this straight. Even the will, because I thought the whole purpose of the will was laying out who gets what and who gets, divvying up the assets and all that. So even though that is specifically, divvied up within the language of the will, you still have to go through the court process.
Yes. And there's a logic to it. Okay. Because with a living trust, presumably you've met with an attorney, you've had witnesses that witnessed you sign it and all of that. So there's been some verification of your intent in that process, right? There's been some conversations with professionals verifying that you are of sound mind and making your own decisions.
Okay.
With a will, if nobody else was involved in the process of writing it necessarily, which is not mandated to create a will with an attorney, there's a higher chance of fraud.
Right.
Right? So the state is trying to protect people by mandating this probate process.
Right.
That's the purpose. Because with a will, you can just have someone write something on a cocktail napkin in their own writing, have a holographic will, and have someone else in the random person in the bar, I saw it, someone else, I saw it. And then they go to probate court with that and they say, well, he intended to give me the whole estate. He didn't want to give it to his kids, So the court is trying to protect against fraud.
Okay. So that doesn't even change if you do say go through an attorney and you have the two witnesses and all that, or have it notarized, or does that?
It does not change. That's a very good question. Because it is a will, it is still mandated to go through the probate process, even if it was prepared by an attorney and witnessed.
Wow. That's important to know.
That's just the nature of the way the law is.
Yeah. Yeah, I understand that. Yeah, I definitely understand the intent of the law. As usual with the law, though, it doesn't allow common sense sometimes.
Right, exactly.
Yes.
Well, it sounds like you just kind of just get rid of wills and have everyone just get trust.
Well, if there's an emergency situation and you don't have time.
Oh, right.
You might just want to be able to write a will really quick.
Okay.
I've heard of that, for example, when people have to travel suddenly and they don't have time to go gather all their assets. They don't have time to get bank statements or anything. I have to leave in 3 days, and maybe they have small children at home or something that they're worried about. Write out a will as fast as you can. Make sure that you have some sort of protection before you get on a plane to travel, right?
Okay.
So that's why we want to still have that option around and can't just completely get rid of wills and only have living trust. They take some time and effort to prepare. So if you're in an emergency situation, that's another common situation where you'll see someone write a quick will just to make sure that their intent is out there.
Absolutely. I mean, when you say it that way, that makes sense. I mean, especially let's say, if you're like on your deathbed or whatever, and it's like, hey, writing out my will, obviously you won't have time to do a trust and everything like that. So at least you kind of have your, I guess, what you intend to have the court, distribute your assets and allocate how you would like. So I guess you're providing some type of instruction, but it still comes down to going to probate and doing all these things. You know what I mean?
Yes.
Yeah.
Great question.
So I have a question. So let's say you either got a living trust or you went through an attorney, you got a will, right? But at some point, for whatever reason, you're in a situation where you want to do the holographic will because you want to make some changes or whatever. Maybe you're in a deathbed. Someone you were going to give something to made you mad, and you're like, I'm not giving them anything. You write the holographic one out. How does that all work now?
Okay, so they're going to order them with precedence given to the last written document. Okay, so presuming that later changes were intentional. Now, it's a very good question. What happens if you have a living trust and then you write a will later? You would have to write in the heading of that will that you intended to revoke all prior living trusts and wills.
Oh, wow. So you'd have to put that in writing that you are revoking, as opposed to, well, you can see here, this is dated 5 years, after I wrote the trust, so don't you just follow that? Oh, wow.
And there's another situation where you're going to see it go to the courthouse. Because if someone gets written out of a will or a trust at the last minute, they're going to probably take that to the courthouse.
I bet.
They weren't in the right state of mind. They didn't know what they were talking about. They totally want to give you everything. What are you talking about?
Yeah.
Yeah, just thinking, what is the last one you want to burn everybody? I don't know.
Yeah, absolutely.
I'm taking it with me.
We're right, exactly. That's what I'm saying. I mean, just based on a person's, situation or something, or maybe they lose their mind or whatever. It's like, oh yeah, I'm not giving anything away. It's like, wait a second. Like maybe we have to do some type of analysis or check.
And that's why we have the witnesses also. Because if the witnesses say someone wrote a strange will later on and they were suffering from dementia or Alzheimer's and it was something very strange, the witnesses are there to say, okay, I saw this person and they were of sound mind and body when making this decision. And that would be another point why the court is going to interpret things with wills, and it's important to have your witness with their name, address, phone number, and correct contact information, so that they can be later called on as a witness to say that this was this person's intent at that time and that they were of sound mind and body making decisions.
Right, and I would imagine they do that every time you have a will, right? They always call the witnesses and check and everything like that. So. Yeah. Okay, but obviously with the trust, you don't have to do that because you've
gone through that process.
You've already gone through the process.
Correct.
Well, okay. Yeah. So what are things that you hear, like when it comes to people that don't have a will or trust? Like, what are some of the excuses that you hear, or maybe things out there you think a lot of people think why they like they're maybe not maybe they shouldn't have it, a will or a trust.
Well, some of the excuses that I've heard are, for example, I don't have time. I'm still really young, and nothing's going to happen to me.
You're invincible. Yeah, Superman. Yeah, definitely. You eat your vegetables. You go to the gym every day. Come on.
Yeah. And actually, that's one of the issues that is really dear to my heart, especially since you pointed out I'm a mompreneur. So I have small children, and I think as a parent, it's just being responsible to go out there and have a will or a trust to say, this is how I want things distributed for my children. Without that intent, and in fact, with the living trust, you can designate who you would want to be guardian of your children should something happen to the parents, right? Which is another really important thing. Young people think that they don't need these things,
right?
But actually, if you really want to look out for your kids and look out for your young family, that's an important way to do that.
So how would it work? Okay, so I have 1-year-old at home. So for some reason, I wanted to leave my house to him. How would that work? In
the living trust, you would designate what's called a children's trust, and you would write an age, be it 18 or 21 or 27 or upon graduation from college or whatever contingency you feel that your child would be mature enough to receive their inheritance. You can write that someone's going to manage that trust for that child until they reach that age or that event in life that you decided that they could be responsible enough to receive their inheritance.
Okay. And who is that person usually?
Oh, it's whoever you designate it to be. For example, for my husband and I, we designated one of their uncles that we feel is the responsible uncle.
Right. Only one, huh?
Yeah, I'm saying you gotta find that one. There's only that one.
Well,
yeah.
You either want 1 or 3. You never want 2, right? Can you think of why?
Because if there's a disagreement.
Exactly.
There's no 50-50 or whatever.
Yeah, you want there to be a majority vote. So you either want 1 person or 3 people. You never want just the 2 uncles or something like that.
Okay, that makes sense.
Oh, wow, okay. Wow.
So when would you say is a good time? I mean, obviously, once you're probably married and definitely when kids are in the picture. Other than that, I mean, is there a particular age? Is there particular accomplishments, a certain amount of assets? Like, when would you suggest that someone gets a will or a trust?
I would say as soon as you become a property owner in California, you definitely need to have I would suggest a living trust if you're a property owner.
Okay.
Because you don't want to go through that, have your family potentially go through that difficulty of having to go through probate court to be able to take care of your estate if you have a piece of property that could be at risk.
Right. That's a good idea.
Yeah, definitely. Yeah, so Adriana, do you help people with wills and trusts, like in terms of, like, they came to you and it's like, hey, I want to write up a will or I want to write up a trust?
Yeah, that's exactly what I do. That's part of my practice areas. So I help people with usually their trust. Usually I try and talk them into their trust instead of their will, unless there's an emergency situation where we have no time. But then usually I say, okay, and after you get back from that trip, call me back and we'll write your trust, because this will is not going to be enough.
Right.
Yeah, absolutely.
Don't go bungee jumping.
No bungee jumping, no skydiving, no alligator wrestling, like none of that stuff, right?
Yeah.
Okay, perfect. Yeah. So obviously you've been doing, estate, probate, attorney. So like, what's some of like the craziest stuff that you've run into, or like, like really complicated like cases you work on?
So some difficulties that I'm seeing talking about this whole difference between a will and a trust. In California, the probate system is very slow. You have to apply to the court for everything, for permission to appoint someone, permission to sell a property. And the problem that I'm seeing for people, largely younger people that have died unexpectedly that were property owners, for their family who they didn't necessarily have life insurance policies to pay the mortgage payment when they passed. Right?
That's a big one.
Because it was young people, unexpected deaths. And what can frequently happen is the family can afford the mortgage. So they're not paying the mortgage. The property starts to go into the foreclosure process. Often people don't come to my doorstep until they have a foreclosure notice in their hands, which shortens the timeline for us to be able to get someone appointed through probate court. And then the property that this person left behind and probably would have wanted to go to children or siblings or family is now at risk of being sold at a foreclosure auction, losing all kinds of value in the meantime before we can get into the probate court to get someone appointed and get permission for sale. So that's why, like, as you asked, the most important time to have a living trust written up is as soon as you become a property owner. I would just say, consider that part of your closing cost is put some money aside and just go put it into your trust right away.
That's a great point.
Yeah, definitely. Yeah. So in terms of, like you said, getting the foreclosure notice and all that kind of stuff, like what's the average time frame?
In California, we're a non-judicial foreclosure state, so they just have to send and publicize notices. There's no actual court hearing or court date. There's usually just an auction date set.
Okay.
And so it can be as short as 4 to 6 months before your home gets foreclosed on.
Jeez.
Yeah. Yeah. And the probate process can take a year to 2 years.
Right.
So you can do the math on that one.
Yeah. Wow.
It's a big risk.
Yeah. So pretty much, obviously, so like, are you dealing with any cases right now where, you kind of run into that situation?
I've been dealing with a few cases. I can't give specific details because I don't want to give any identifiable
for sure,
information out
Jane
there.
Doe. Jane Doe.
But that's exactly what I've been dealing with in a situation where we're trying to avoid a foreclosure as soon as next month. So it is very sad and very heartbreaking for the families. Even when I'm doing everything that I can, lenders and banks are not the easiest to deal with getting information in a timely fashion, often when the person who was on the note and the deed is no longer there. Right. So they're not, you run into another problem with who is legally authorized to talk to them.
Exactly.
Yeah, and I feel, I've heard that a lot for sure. Because, because if the person's not there, it's like, hey, how can I talk to you? I need something from the court saying that, they're giving they're giving you permission to speak to me. So I definitely have seen them run into that situation.
Yeah. I'm dealing with a situation exactly like that today.
Yeah.
So how does it work with like property that's sold through a probate sale?
Through a probate sale.
Yeah.
It's interesting. So you, again, have to do the publications and the notices. And they are actually going to, there's two ways. So if they give full independent administration of trust powers, it can just be sold through whatever realtor you pick.
Right.
As a regular process. Now, let's suppose that the court, for some reason or another, did not decide to give the person that your family appointed full administrative powers. They're actually going to hold the sale in the courthouse at a hearing. And people can come and bid as long as they have cash on the house. So a lot of times you'll see that they have a buyer arranged, and the buyer's going to come with usually cash bids. But if someone bids over that prearranged sale price in the courtroom, the judge is obligated to take that sale. So it can become an interesting bidding war in the courthouse before the judge, because they're trying to get the highest value they can for your heirs. Right. So, yeah, it's interesting.
Okay, and you have to be able to pay cash.
You have to be able to pay cash.
Wow.
It's more than likely an investor might end up buying that property then, unfortunately.
Yes.
Not another family.
Frequently, yes.
Yeah, and they could actually end up overpaying for it.
And especially in this market. Well, it depends on how the market's doing, right?
Yeah, for sure.
Yeah. But if you have to bid on it, because you don't get a chance to do an appraisal prior to, right? I'm assuming they don't have an appraisal.
Well, it's published that there's going to be a probate sale in the courtroom. So in theory, if they did their due diligence before, they could go and check it out. They might not be able to go inside, but they might be able to see the outside of the property.
Right.
But yeah, it's an interesting situation.
I watch a lot of Flip or Flop, so then they'll see the property from outside a lot of the times, and then once they buy it, they get inside. It's like just the roof caving in and
all the copper's gone.
Right. There's a decaying body in one of the rooms.
I haven't seen that episode. Which one's that one? Decaying body. Is that episode 80? What episode is that?
There was one where they left an abandoned car behind.
Yeah, I've heard of that.
Tore up, but
I've seen that before.
So it's at your own risk, I guess.
Yeah, for sure. Yeah, so when it comes to those types of sales, I mean, and at the house that you go to, I mean, do you see like a sign? Do you see like auction or like a for sale sign? Like
no, it's usually published in one of the legal newspaper publications. So the one that I often use is the Mission Viejo News. They have it, when you go through the newspaper and you go to the back and there's all those classifieds and public notices. That's where you're going to see these publications of probate sales.
Okay. Would something like that be like in the register? Or
They could have it in the register. There's a list that the courthouse keeps of approved newspapers that changes from year to year that you can use for publication.
Huh. How can someone get a hold of those if they want to go
of that list?
Yeah. The papers that they put them in.
You would just have to go buy all the issues of the paper every Sunday and check it out. I don't know if they have an electronic version. Right. I haven't been asked that question before, but I'm sure there is some investor somewhere that's got some secret to that.
Right. So does the courthouse put anywhere, let's say on their website, a list of publications where they produce that information?
The courthouse publicizes it? No.
Okay.
No, but it goes out in the newspapers.
Okay. That'd be interesting to find.
Yeah.
Now, like you said, the newspaper that you referenced is the Mission Viejo. Now, is it just covering like South County, or is it covering all of Orange County?
Interesting question. So I could be selling a probate in La Habra and still publish it in the Mission Viejo News, as long as that newspaper is on the list of approved papers from the courthouse. It's fine.
Okay, perfect. So it's not just geographically categorized. It's just that newspaper can have any house in there in Orange County.
It's just that I've been working with them for years and years, and they have a good price, and I know who to email with all of my details. So that's why I picked them, because I've been working with them for almost 7 years now.
Okay, perfect.
I'm sure every attorney has their own preference on that.
Right.
Yeah.
So how long does the process take to get a trust together, and what is that process like?
I've gotten a trust completed in as few as 3 days. When I had a really organized client, they came in with all of his statements and a copy of his grant deed and everything. And I've had clients that have taken 6 months because they don't like to go and collect their statements or find their retirement accounts, or
they're just unorganized.
Yes. So it's really dependent on the client how long that process takes.
Okay.
Staying organized and collecting everything before you go to see your attorney is a great idea. Your attorney will love you. They might even give you a discount for that. I would. So,
so what
that's a
kind
piece of advice.
So what kind of documents would you need? Like, is it like the most recent bank statements, the most recent mortgage statement, or deed of trust, or?
Yeah, you're going to want all of your most recent bank statements, savings, checkings, retirement accounts, IRAs, 401ks, 403bs, 457s, all of those. You're going to want the actual deed to your property, right? So it's not necessarily the promissory note. It's the deed that has the legal description of the property, usually called Exhibit A.
Yeah.
Okay.
And any other, you want to know the VIN number and license plate on your car.
Right.
Basically, any of your assets that you own. You're going to want to have whatever piece of title information you have for all of those assets, because they're going to be listed in your trust. Now, with cars, often what I do is something called a pour-over will that is part of the trust package. And so it's a more fluid document. You're going to put things like your checking account and your home into the trust. But with things like your car, where you might get a new one every 3-4 years or something like that, you want to write it into that pour-over will that you can easily amend later. And also there's a clause in that pour-over will that's going to say anything that wasn't previously listed is designated to go into the trust. So it's like a catch-all.
Right.
Oh, nice.
Yeah. So if your assets or your cars or your bank accounts or anything changes later, you have that contingency provision that's going to still protect you.
Okay. How detailed should one get, right? So I have don't laugh at me. So I have all my collector's items from comic books and, Batman figurines. I've got my Star Wars novel collection. How detailed do people get? Is it the only thing of value or just anything and everything?
It's anything that you want to specifically give to someone.
Okay.
So that's up to you. If it has a very emotional value and there's somebody in particular you want to give that to, you can write that in a will or a trust.
Okay.
And with women, I've seen them go through their jewelry collections and decide,
absolutely.
I want to give this ring to this person and this necklace to this person.
Okay.
So it can be fun deciding who you're going to give things to, even though it's, people sometimes don't want to think about it, but there can be a fun aspect to it of saying, these are my things that are important to me that have emotional value and I want to pass them on. Okay.
So anything that's not specifically detailed in the will, how does the court handle with how that's allocated?
Okay, so there's what are called testamentary rules of the estate. So you're going to have, so for example, if you have children, usually they're going to divide equally between the children.
Okay.
Or one of the ones that sometimes becomes relevant is if you never married and didn't have children, usually it goes back up to your parents would be the ones that would inherit from you. But usually when it's not specifically written, they're going to find the class of people that should be your heirs and they're going to do an equal division.
Okay. Okay, cool.
Yeah, it's good to know. And I guess you don't have to worry about anyone getting mad about that because you'll be gone. When this happens, hey, I'm not here when you guys are arguing about things. Hey, whoever you decide to leave your collectible items to.
Yeah.
So, yeah, definitely. Yeah. So like you said, when it comes to the house and the bidding process and not having a sign on the house, so pretty much someone could just be walking around the neighborhood, not know that a house down the street is for auction if they don't have access to the Mission Video or any of these publications. That's wild. I would think that there would be some type of this house would go for. I would think there would be some type of notice, but it's no, it's just right there, and the house has to be bought with cash.
If it's going to this bidding process at the courthouse, if they gave the administrator of the estate full authority, they can just
sell as a traditional,
through a realtor.
Okay, but the bidding is it goes to bidding because of what's the reason why it would go to bidding as opposed to having them do a traditional sale?
Well, usually it's because the court was not very happy with something about the personal representative that was appointed.
You're talking about the trustee.
Well, there's different language. So if it's a living trust, if it's a trustee, if it's in probate, it's a personal representative appointed by the court. So there's legal difference in the terms. But one example, suppose that the person that wanted to apply to be the legal representative didn't have the best credit score. which could represent that they're not very fiscally responsible, right? So in those situations, sometimes we see the court decide they're going to handle the money and they're going to handle the auction in the courtroom because they want to make sure that everything is done properly and that the distribution is done properly. So that would be a situation where you might see the courthouse not give full administrative powers to the personal representative.
I'm sorry, just one question after that. So if so the court wouldn't be able to say, okay, well, can we find somebody else that could be a better representative? Like, they wouldn't be able to do that. They would just kind of like, all right, this person, we don't like them, we're just going to take care of it ourselves. As opposed to maybe there's another family member or heir or whatever that can. If
someone else wants to come forward and apply, the court would consider it.
Perfect, okay.
But sometimes you have situations where, for example, some people have mental health issues or they're just elderly and can't manage things anymore. So you'll have a younger person that maybe 18, 19 years old doesn't really have a financial record of any kind or a lot of life experience, So there can be situations where there can't be someone else found.
Right.
And also there's a public division that the court can appoint. There's public attorneys that the court can appoint to become the personal representative of the estate. However, that's when you start getting into very expensive probate processes because I've never heard of another attorney working for free.
Oh, wow.
That would be the golden unicorn.
Yeah. So if the court does appoint an attorney from the public system to come and represent you, your estate in the court, you're definitely going to be paying a lot of fees for that from the estate. So they're going to diminish what people are going to inherit.
Yeah.
So initially, I would choose my own personal representative, right?
And you could name someone in the will to be the executor of the will, but the court would still examine that person.
Okay. Otherwise, the court would assign someone.
Correct.
Okay. As far as the examination of that person, how deep are they going? Like you mentioned the credit scores, so they would pull a credit report on this person?
They'd probably pull a credit report. They would probably look at what their assets are. So another thing that can happen is if people don't have a lot of personal assets, the court can ask that you put a bond on that person that's going to be the representative, and those can be very expensive. Usually you have to put up whatever 10% of whatever the bond amount. So say they want a $100,000 bond,
right?
You're going to have to put up $10,000 to receive that bond.
Wow.
Yeah, so these are the nuances where a probate court can get very difficult. Now, with a living trust, there's no court to investigate who you've named as your trustee.
Okay.
So there's a little bit more freedom to name whomever you want. Now, I always advise people, you want to think about these things and consider who's responsible that you want to name as trustee. But at least there's no court intervention.
Okay. So basically, when it comes to the difference between a trust and a will, because we talked about cost early on, it's better to pay that cost up front in the form of a trust than to pay a lot more money later on because you have a will and you're done with the probate court.
Well, it's always up to personal choice and personal opinion, but that's how I feel.
Right. I mean, it just makes sense because, like I said, you could pay, $1,000 or a couple thousand more right now, and your family and whoever's dealing with that situation once you're out of the picture, it's going to cost them a lot less, and they can get things done a lot faster or a lot cheaper once you're gone. So, you can either spend it up front out of your own pocket and let them have most of what you're leaving behind, or you can have them go through the probate process. Whoops. You can have them go through the probate process and have a lot more of what you intended for them to have be eaten up by fees.
Yeah, for sure, easily.
Yeah, I couldn't say it better myself. That is an exact encapsulation of the situation.
Okay. And then do you pick up a backup person? Like if you're doing the will, you have the original trustee, you pick up a backup person in case that something happens to that trustee.
Right.
Yes.
Yeah.
Yes. Usually I'll have people pick an order of succession is what they call that.
Okay.
And usually I'll have people at least choose 2, if not 3 people, or also you could have joint trustees or joint executors that you would want to be possibly appointed to administer.
Right.
So that's a very good point. You want to have backup people. Say something else, I have a younger brother, but what if he passed away before I did, right? Something happened. So you want to have those backups written into the document.
Okay. And then if you ever want to, make changes, so let's say today you're married, right? And obviously your spouse is involved in all of this. And at some point you guys aren't married. Do you have to pay to get an entire new trust, or can they just add like an addendum to the end of the original trust? Or
well, you could do either. So with the trust, we call it an addendum or an amendment. With the will, we call it a codicil. But you can always later amend or change or make changes to these documents. That is one of the number one reasons I have people coming into my office for trust revisions is after a divorce. Right. Because they've separated everything. The assets are different. And they want to make sure that things go to maybe their children or other heirs rather than to their ex-spouse. So that is a very good, another reason why people often come to revise a trust or change a trust.
Okay. And since you brought up the divorce, does what's in the trust have any impact on how things are handled through the divorce? So like, let's say I'm leaving my wife a bunch of stuff through the trust and now we're getting divorced. Do they look at the trust and say, well, you still got to give all that to her because...
No, the divorce decree is going to preempt whatever you wrote into the trust. Okay. Yeah, that's a good question, too. Yeah.
I'm not going to think about it. I'm just,
I think you might get it.
No. I'm asking on behalf of my wife. She needs to know these things.
There you go.
I like that cover.
Wow, this is all very interesting.
Yeah, definitely.
I should have went through with law school.
I was telling Adriana that was my path. I wanted to go to law school. So at least someone I know did it. Yeah, we actually had a question. Let me see if I can scroll it here. Let's see. I wanted to make a document that specifies my children as beneficiaries of my bank accounts, car, and anything else I can't think of right now. What document should I do since they are underage? What is the process for that? Again, sorry if you answer this, but I'm at work watching Laugh Out Loud. Thank you for watching, Annie.
Yeah, thank you. So that's a great question. With bank accounts, if you want to do that really quickly, you can actually go to your bank and say, I want to designate the paid on death provision of your bank account. And the bank will allow you to write your children in as the recipients of the bank account, and all they have to do is present a death certificate if they were written in there.
Oh, okay.
So that's a really quick way to do it. However, if you're thinking long-term and you want to designate, who would be a guardian and who would be trusted with managing their finances should something happen to you while they're still minor children, then you're going to want that living trust with a children's trust written into it.
Okay. Yeah, okay. Hope you got all that, Uni. And if you didn't, Adriana's information will be on the post. So if you have any questions, you can feel free to reach out to her. And yeah, thank you, Adriana, for providing all this great information. I've learned a lot. Everybody out there should get a trust.
I did have one.
I'm sorry.
Question.
One more.
So we talked about the car in terms of ownership. What happens with a lease?
You can still designate it, but it would only be until the expiration of the lease. And actually the lender would have the option to decide that the person's not creditworthy and they don't want to extend the lease. So you can try. That's how I would say you can try, but it would still be up to the discretion of the lender.
Right. And I'm not even saying from the standpoint that they would want to keep the lease, because what if the spouse doesn't want the lease? Are they responsible to pay for it, or can they just turn it in and say, hey, the person you had a contract with is no longer here?
Well, if it was a spouse, unfortunately in California, we're under community property rules. So I would say the lender would more than likely be able to still collect that debt of what the balance of the lease that was owed from the spouse.
Wow.
But that's one of the things that you want to think about, having maybe something like a life insurance policy to pay those kinds of things, or to pay final expenses and final debts to protect against those kinds of issues.
Because all the credit cards that you owe, student loans, that's all being passed on to.
Don't get me started on student loans.
Wow, man.
Yeah, you of all people.
Right. I did not know that because I figured, like if your spouse is not on these documents, how could they be responsible for that? But because of the fact that you're married in this community property, it's like, wow, totally not know that. Wow, okay.
Yeah. It's till death do you part, not debt do you part.
I like that. That's a nice tagline.
Wow, that's interesting.
Jeez.
So you got to, just for all you out there, you have an added incentive to make sure that your spouse keeps their debt in check.
I would agree.
Yeah, absolutely.
Yep.
Oh, wow. Jeez. Wow, I totally did not know that. Wow. I know that now. Because, so anything like car, credit card, student loans, all that stuff just gets moved on to the spouse, even though the spouse never signed it or anything. Okay, what if you got this stuff before you were married, though?
Then it goes to case law, and I would say that would be a question on a case-by-case basis. It would depend on whether it was to support the family. So, for example, with student loans is its own whole situation, but that's become an issue recently in student loan regulation area where they actually have a provision in most student loans where they can accelerate the debt and make it all due in full upon the death of the person that was the borrowing student, right?
Wow.
And there's a lot of uproar about this provision.
Absolutely, that's ridiculous.
You're literally like, going to a funeral and grieving a loved one, and then you get served with a notice that says, by the way,
here's a bill for $100,000.
Yes.
Wow.
Right.
Yes. So, and if that education was being used to support the family, there is somewhat of an argument that it might still be owed.
Right.
Wow.
So you're an attorney. You paid money to go to law school. Your attorney, your profession as an attorney was created by the law school and paying for your family. So now they got you.
Yep. Well, it's being argued in the court system and with regulators right now. But as of this moment, they still have permission to accelerate those student loans and make them paid and due in full upon the death of the student by spouses or co-signers.
Okay.
So I would say keep an eye on the law to see if there's changes in the future, but that's a really good reason to work on building your home equity, work on having life insurance policies or something
for sure.
so that you can cover your expenses for your family.
Now, in the case where you're a single parent and the parent passes away, what are the obligations of the children?
Well, it's actually the obligation of the estate at that point, right? And so the debts are going to be paid out of the estate before anything left over goes to the children's trust.
Right. But if there is nothing in the estate, the children have no responsibility there.
You mean, would they be stuck with the balance? Probably not.
Okay.
Probably not, as minor children.
Okay.
But you heard...
You said minor children, too.
Probably. Those are good questions, and I can't fully answer that because I would have to go and research case history and see if anything's been presented to the court on that. I would presume, since they are under 18, that they would not become responsible all of a sudden when they turn 18.
Right.
That seems like it would be inequitable. But I can't promise what the lenders do or what the government decides on the law. So.
And if they're over 18, it's another coin flip.
Yeah, I don't know. But I would presume since if they were not co-signers, they would basically just liquidate all the assets of the estate and end up without an inheritance, unfortunately.
Because there were always like these old wives' tales about what happens if your parents die with a bunch of debt and whatnot. And, so I thought I'd ask the question because a lot of people don't know. I didn't even know actually. So.
Yeah. Wow.
Yeah. Usually they're just gonna exhaust whatever assets were in the estate first, and then if there still wasn't anything left, you can't sue a minor. Right. So it would just be they would have to write off the loss.
Would just have to eat the loss.
Yeah.
Okay. Cool.
Wow. Learned a lot today. Jeez. Wow. So get those trusts. That's all I have to say to you guys. Just get the trust. I mean. Get the trust. Get the trust. Get the trust.
Get it yesterday.
Yesterday. Yeah, definitely. So what I'm going to have you do, Adriana, with the question that Yini asked, I'll probably just ask you and then I'll type it up so that she can reference it back.
Okay.
Yeah, so definitely do that. And one did say, thank you for taking time out of your busy schedule to be with us today. And
it's been a pleasure. Thank you for inviting me.
Of course, this is fun. And I learned so much about wills and trusts. And I'm sure a lot of you guys out there learned a lot about wills and trusts as well. And also, remember, I'm going to leave this post up so you guys can watch it, replay it as many times as you want, save some of the information. And if you guys have any estate, probate, wills, trust needs, or anything like that, reach out to Adriana. She's a wealth of knowledge. She's very easy to talk to, easy to work with. She breaks things down into layman's terms so you actually understand it. And her contact information is going to be here. And if you reach out to me and if you need any type of estate or probate assistance, I'll definitely refer you to Adriana. She's great. She's definitely one of my referral partners, and I trust everything that she does. So, yeah, we'll definitely do that. And like I said, thank you guys again for tuning in. I just also want to let you know about a fundraiser that's actually going on. It's actually at the Alexander Salon, Bryna in Anaheim Hills. They're doing a cut-a-thon. It's next Sunday, and it's June 10th from 11 to 4. And it's benefiting the support of Orange County Foundation for Oncology Children and Families. So it's a volunteer organization that provides support activities free of charge to pediatric cancer patients and their families. So activities include trips to amusement parks, barbecues, and they also do this thing called the World's Greatest Camp. So that Sunday, they're going to be doing women's haircuts, $20, with a blow dry, $35. So, I don't really have a lot of hair up here, so, so unfortunately, I'm sorry, and they also have men's and children's haircuts for $15. Chair massages, $1 per minute. So, I might be able to get a chair massage, $1 per minute. Okay, that's not too bad. They're also doing brow waxes for $10, lip wax for $5, face painting for kids for $5, and they're also doing a beamer treatment. It's $10 for 18 minutes. So I guess what it does, it enhances your blood flow, cardiac function, stress reduction, sleep management, and more. So they're also doing a raffle opportunity. So they're raffling off gifts. I actually went by the salon earlier this week, and we actually purchased a lot of raffle tickets to help with the foundation. They're raffling off Dodger tickets. They're also raffling off different gift baskets for like popcorn, movies, also health certificates, beauty supply certificates, and also heard they're going to be raffling off a signed football by an NFL player. I believe he plays for the LA Rams, and they may be raffling off some LA Rams tickets. So make sure to stop by there and buy some raffle tickets. And if you guys have time, come to the cut-a-thon. I'm also going to put this information on the post as well, and I'll be talking about it next week up until Sunday, June 10th. So definitely be doing that. And as I said again, thank you guys again for tuning in. Hope you have a great Friday. Hope you have a great weekend. Take advantage of this nice weather. It's June 1st. June is like the best month of the year. You know why June's the best month of the year?
Why?
Because my birthday is June 5th. Oh. Not just because of that. No, June's just awesome. It's like the start of the summer, so it's perfect. But like I said, everyone have a great weekend. Thank you guys for tuning in. We appreciate your likes, shares, and your comments. If you have any questions at all, our contact information is here. Thank you again, Adriana, for taking time. And always, Wes, it's always a pleasure. Thank you for going with me on these crazy Facebook and Instagram lives that we do together and dressing up for all our events. So thank you for doing that. And, yeah, thank you guys for being here.
Okay.
Appreciate it.
Happy Friday.
Yeah, happy Friday.
Happy Friday, everyone.
Yes. And I'll let Wes sign off.
Be assertive. Definitely be proactive when it comes to getting a will. And have a great weekend.
All right.